Welcome to Beyond the Legacy, an extended long-form bonus episode of 60-Second Civics, where we dive more deeply into the issues discussed over the past week. This episode has been prepared especially for the Civil Discourse, an American Legacy project. I'm Mark Gage. We are joined today by our special guest for this series, Dr. Lisa Tetrault, an Associate Professor of History at Carnegie Mellon University. Dr. Tetrault, throughout the past 5 episodes of 60-Second Civics, you've addressed issues of fundamental rights as they've applied to women throughout history. One of the most well-known ways that women have tried to claim their rights under the Constitution is by asserting their right to vote. Most famously, people reference the Seneca Falls Convention. Tell us the story about how Seneca Falls and voting go together.
Thanks, Mark. Good to be with you, and thanks to all the listeners out there. The voting is probably the most famous, or well-known anyway, crusade in the 19th century for rights, to get basic voting rights, which many people call a basic constitutional right. There were many, many, many other ways in which people did pursue rights in the 19th century, including many women who did not find voting to be the most central wrong that they faced or the best solution to what they faced. But that said, it is probably the most well-known crusade of the 19th century. And that is said to have been accomplished, women's suffrage, in 1920 with the passage of the 19th Amendment to the U.S. Constitution, which is said to give women the constitutional right to vote that we all believe we have. And if that's the ending point, the starting point that people often point to is 1848 and the convention in Seneca Falls, New York, thus called the Seneca Falls Convention, which in 1848 was the very first convention called in the United States to explicitly discuss something called women's wrongs or women's rights. It was not the first time people had discussed women's rights. That had been going on for quite a while, nor was the first time that women had been in convention. But never had they been in a publicly announced convention for women's rights explicitly. It was a very local impromptu convention called in July of 1848 in a little tiny town up in the Finger Lakes of New York. It's today the site of a National Historical Park. And at that convention, the organizers, which included Elizabeth Cady Stanton, Lucretia Mott, and some others, drafted a manifesto that they organized the convention around. That manifesto, the Declaration of Sentiments, about which we did a brief episode, made a bunch of demands, and it modeled itself on the Declaration of Independence. And it said, we hold these truths to be self-evident, that all men and women are created equal. And then it listed a whole bunch of grievances against man, particularly in the original, it had been against the king. These included all kinds of important rights, which have not even yet been achieved today. Equal access to the professions, equal wages, an end to the sexual double standard, like all kinds of things. And famously, also the right to vote. This was not the first call for the right to vote, although it's often said to be, nor would it be the last. But it was an important piece of that convention's work.
I'm also curious about the role of Frederick Douglass at the convention and the relationship between the movements for civil rights for African Americans and the women's suffrage movement. Can you talk a little bit about that?
Yeah, so we can look at both kind of the preamble to this convention and also the postscript. Leading up to this convention, part of what had drawn women to women's rights was their work in abolition, and in civil rights of its era. Many women worked in abolition, many white women, and many Black women, and many white women were said to be out of their sphere, as it was. They were supposed to be in the domestic realm, home, not out in the public, and they were supposed to be passive supporters of their husbands. And marriage was sort of the only option white women had in this era. And men were supposed to be out in the public speaking their minds. And so when white women in particular, get engaged in abolition work, they are told, they are denounced, often by ministers and many other people. And this leads a lot of women to start saying, I have a right to speak in public. I have a right to advocate my political opinions, things like that. So many people talk about the women's suffrage movement as growing out of civil rights activism. And then at the convention, because these two causes were so blended, Frederick Douglass lived just north of Seneca Falls in Rochester, New York at the time. He was part of this abolitionist circle that helped organize the Seneca Falls Convention, and he came down for it. Um, and when they made all their demands, they spent the whole 2 days of the convention debating this manifesto that they had written and all of the demands therein. The ninth resolution, which was out of 12, which was the one for the vote, was the most controversial. And there are interesting reasons why. The person to stand up and salvage that claim and keep it as part of the Declaration was Frederick Douglass. Frederick Douglass stood up and made an impassioned plea for the right of women to the elective franchise. And with that, it passed. So he has a very important role in keeping that at the center of that movement and also giving it legitimacy, and also as a lifelong supporter of women's rights.
Now, I'd like to turn, if you don't mind, to the 14th Amendment. So the 14th Amendment was ratified in 1868, which is 7 years before the Minor v. Happersett case. Yet, in Minor v. Happersett, the court found no guarantee to the right to vote for women in the Constitution. How did the 19th Amendment and later interpretations of the 14th Amendment add to women's equality under the law?
So, this is where we get to a part of history that most people are very confused by, because it doesn't make sense. We all know that we have a constitutional right to vote, right? What the court clarifies here is that we do not. And it's not just women that don't have a constitutional right to vote. It's all people do not have a constitutional right to vote. And this case in 1868, the 14th Amendment is ratified in 1868. And we should stop here and say, okay, we had the Seneca Falls Convention, we had abolition, we had all this. Then we had a major civil war. 1860-61 to 1865. War ends 1865. And out of the war come three really, really important amendments. They are thought to be the basis of the modern rights revolution. They give us the modern Constitution. 13th Amendment, abolition of slavery, except as punishment for a crime. I highly recommend you follow up that exception. Lots and lots of work out there to take a look at around that, including a documentary called The 13th. The 14th Amendment was birthright citizenship. So it gave citizenship to African Americans born in the United States. In other words, they would be welcome into the nation as equal citizens. And it also said they got equal protection under the laws, and you couldn't deprive them of their rights without due process. In other words, they would no longer be covered by a separate code of laws. And thirdly, we got black male suffrage, the first suffrage amendment to the U.S. Constitution. That last amendment, the 15th Amendment, which was ratified in 1870, started for the first time a biracial democratic experiment in the United States. And many of the governments across the South elected lots of African Americans, and many of the southern states sent African American delegates to the U.S. Congress. The first black senator in the U.S. history came from Mississippi in 1870, right? We can't imagine that. But there was this brief experiment where black men had the right to vote. That angered many, many people, many white supremacists, and particularly the people who had just been defeated across the South, who were now, as they said, under black rule, which to them was inconceivable. So very quickly, white supremacists went about trying to destroy the 15th Amendment. Okay. At the same time, we also have this women's suffrage movement that's been plodding along since abolition. And they're saying, hey, we want the right to vote too. You just gave black men the right to vote. And white women are saying, what about us? And so they're trying to figure out, how can we creatively use these amendments to argue that we are also enfranchised? Because the 15th Amendment did not include gender or sex. It only included race. And it didn't include... Well, I'll get to that in a minute. white women and a variety of African American women as well, who are not allowed to vote by the 15th Amendment, start just going to the polls and voting. It's a whole strategy. It's why famously Susan B. Anthony will be arrested for voting in 1872. In 1872, a bunch of women just go to the polls and start voting. And they had done this earlier too. A whole bunch of Black women had gone to the polls and started voting in Washington, D.C., all around the country. And what they do is they want to take their illegal voting, right, to the courts and have the courts decide that it is in fact legal. So they go out and start voting. The person's case who makes its way all the way up to the United States Supreme Court, one of these women who voted, was Virginia Minor. Her case goes to the United States Supreme Court, and in Minor v. Happersett, the court rejects her argument. Her argument is, I am a U.S. citizen, 14th Amendment, right? I, therefore, also have the right to vote declared in the 15th Amendment because I am a citizen. And we all know that citizenship comes with a basic fundamental right to vote. This is where it gets kind of amazing because the Supreme Court says no. They are also part of this pushback against the 15th Amendment to say, we are not going to read that broadly to interpret it as giving people the right to vote, not just American women, but also African American men. And it will be a companion decision with another decision where a Black man protests that his vote was not taken in 1876, a year later. Minor v. Happersett is 75, and United States v. Reese is 76. And in that, the Supreme Court says the 15th Amendment gives no one the right to vote. The Constitution gives no one the right to vote. There is no constitutional right to vote. It is a privilege, and the states can deny it on any grounds they see fit except one. And that is the one that was in the 15th Amendment that said race. And they argued that Victoria Minor had no standing under the 15th Amendment because she wasn't being discriminated upon race, only upon sex. Therefore, she did not have the right to vote as a citizen. So that court case reminds us that although we open this with how women have pursued a constitutional right to vote, interestingly, that has never been achieved by American citizens of any stripe. We still in this day have no constitutional right to vote.
That's really astounding.
It is. And many people are very shocked by that. And that's why we're in the midst of a massive wave of disenfranchisement, because the states can still restrict as they see fit, except for the ways that they've been stopped from restricting by the federal government or the U.S. Constitution.
I see. Now, turning down now to a more modern debate about equal protection, I'd like to address the Equal Rights Amendment. And if you'll entertain me for a moment, Section 1 of the proposed ERA reads as follows. Women shall have equal rights in the United States and every place subject to its jurisdiction. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. This doesn't sound very controversial to me, but why has the ERA attracted so much opposition over the years, and what are the barriers to its ratification now?
So when the 19th Amendment is ratified in 1920, women are looking around and thinking, what should we do now? At least those women who were covered by the 19th Amendment. Many African American women and women of color still couldn't vote after 1920. And that was because the amendment only said states could not discriminate on the basis of sex. Those states could still discriminate on the basis of poll taxes and literacy tests, which had just previously disenfranchised Black men, in spite of the 15th Amendment. So those women looked to white women suffragists and said, your cause now should be to help us vote, right, to continue this work. And those white women said no. And that was a big problem. And many African American women went on and fought for all kinds of things, including their voting rights after 1920. And Latino women and indigenous women went on to fight many other causes. Those white suffragists, however, who were satisfied with the 19th Amendment, would cast about, and eventually Alice Paul, one of the famous suffragists, would settle upon the idea that we just won this amendment that says you cannot discriminate in voting on the basis of sex. How about an amendment that says you can't discriminate on the basis of sex, period, in anything? And Alice Paul will decide to launch that crusade in 1923, and she will go to Seneca Falls to unveil the first version of the Equal Rights Amendment. hearkening back, obviously, to that idea that this is where the vote began. The vote is ostensibly now over, and this is our next crusade, when in fact it didn't begin in 1848, and it certainly didn't end in 1920. In the 1920s and well up to today, and certainly in the 60s and the 70s when it was most prominent, many people believe that men and women are not fundamentally the same. They are, in fact, different creatures, right? And therefore they should be treated differently. And so fair treatment under the law is actually discriminatory in the eyes of some people, right? It hurts women because it says that they have to be treated like men, and women are different and special, and therefore they should have special, men and women are not the same creature, therefore they should not be treated the same. That's one reason why it's had a lot of opposition over the years. And another reason is that idea that has been true for a very long time that we were talking about earlier in the opposition to women being out advocating for abolition, that they were out of their sphere, right? Men and women inhabit different, they do complementary but different things in society. That argument had been used at the end of the 19th, early 20th century to create special protections for women in the labor force. So one of the things people had done to try to get rights was to get protection from capitalists so that they couldn't work you 80 hours a week. They couldn't put you in dangerous situations. They had to pay you if you got wounded on the job, right? All of these things. That kind of labor protection, which had been a major fight of the union movement, put in place for women, but not for men in many cases, because women were thought to deserve special protection because of their special procreative function. So women got limited hours, they got special protections, and many, many labor activists didn't want an ERA because it would destroy the gains that they had made in at least women's industrial labor work. Lastly, the reason many people oppose this today and other times is that a lot of people think it's already been achieved, that we don't have sex discrimination anymore. And so it's an interesting, it is a very, very simple statement, no discrimination based on sex. It is a very fraught and very difficult concept in this nation. And I'll just add to this. Can I add one more thing? The person who made that true in law for the very first time was the recently departed Ruth Bader Ginsburg, or the notorious RBG. Sex discrimination was entirely legal in this country, always, except in voting. That was the one place you could not discriminate in application of law. Classified ads for jobs used to be, help wanted male, help wanted female. That was all considered perfectly legitimate until a variety of cases that Ruth Bader Ginsburg and other people argued before the United States Supreme Court in the 1970s. And it wasn't until the 1970s as the Supreme Court said differential treatment based on sex is in fact discriminatory. So that's a very recent idea, which also tells you if the court's been that slow to acknowledge that, then you can imagine why we haven't yet put it into the Constitution.
Well, thank you. Thank you for that. What do you think, just out of curiosity, what do you think are the chances that the ERA will ever be adopted?
No idea. No
Given today's political atmosphere.
I am no fortune teller. Yeah, I don't know.
Well, thank you so much for joining us for this series, Dr. Tetrault. It's been an honor speaking with you. And that's all for today's podcast. For 60 Second Civics, I'm Mark Gage.